Moving on, we talked about persecution. We talked a lot about pogroms and all of the persecution that they experienced back in Europe. We're going to talk a little bit about representing people who are unpopular, who may be repugnant, according to RPC 1.16b4. One has no obligation to represent a client who one deems to be repugnant. How exactly do we define that? So we'll turn to clip number 2 and get this show on the road.
And most important of all, our beloved Rabbi.
Rabbi, may I ask you a question?
Certainly, Labish.
Is there a proper blessing for the Tsar?
A blessing for the Tsar, of course. May God bless and keep the Tsar far away from us.
I guess they didn't have the option of just impeaching a czar whenever they wanted to, right? Had to throw it in somewhere. You know, people asked, how'd you come up with this topic? I said, there's been nothing going on in Washington the past couple months, and it's just been quiet, so we thought we'd talk about Fiddler. But here you have a czar, you have real anti-Semites. They're really bad people in this world, and as a rule, I have yet to see bad people who can't find representation. There's always someone willing to represent them. Everyone's entitled to representation, but as an attorney, should you represent someone you deem to be a czar, despicable, repugnant, use whatever word you want? What is the balance between those two? Chris?
If we didn't represent people who are unpopular, we'd be out of business. That's what we do. At least in my area of the practice, we represent people who are in trouble, who've been accused, who themselves may have been persecuted. My approach, which I think is different than probably many others in the room, is I try very hard not to make judgments about people based on their beliefs or their politics. I tried very hard as Attorney General to stay out of politics and to stay true to what I thought was right. And it makes it easy for me in the representation of private individuals now in companies. I really, unless it's something that is going to cause the law firm true harm.
Give me an example.
Well,
theoretical.
A theoretical example, which is not so theoretical, is representing the interests of the President of the United States. We've seen it. There are law firms that have undertaken representation of the President in his own private pursuits, and clients have walked out the door. There's real risk associated with a decision like that. I'd like to think that I would make that decision on a principled basis, but reality creeps in to that analysis.
Larry, help us out over here.
So when I started at Gibbons, some of you may know I run this Gibbons Fellowship Program, which takes on constitutional causes, often unpopular ones. I remember early on I took on a death penalty case that was really particularly horrific, and began a course of representing murderers on death row around the country. And I thought that made me very unpopular at times in my firm. And then when Megan's Law was enacted, I decided I would represent sex offenders in challenging Megan's Law, and that made me very unpopular in the town of Chatham where I live. And then I was assigned to a case that I really liked, in which a sex offender was trying to get playboys brought into the prison where he was, and I was vigorous in my sense that violated the First Amendment, and that made me very unpopular with my mother, which actually had certain benefits. But I really truly believe that we have an obligation to represent the most despised among us. And I've spent a lot of my career representing people on death row, people in Guantanamo, enemy combatants, people who deserve the benefits of the law no matter what they've done. Having said that, I think we need to be clear about it. There are limits on who we have to represent and should represent. I do believe that, obviously there are conflicts that we have to run, and when there are conflicts of interest, we can't represent people who are in conflict. And obviously, as Chris pointed out, there are business realities that creep in, and sometimes we don't represent somebody because it'll be bad for the business of our firms. But sometimes...
Do you let clients make that determination? If clients say, we don't want you to represent that guy, how much of a voice does that have?
So I'm not the boss of my firm, and I don't have to make those tough calls.
Where's Mike Griffin?
But it's a reality. I mean, before I can take in a case, our firm makes a decision about whether that will be a good or bad thing for the firm. It's not what the clients think, it's what the overall, in order for us to survive and for me to represent all the many people, and they're very tolerant of my ability to represent really unpopular causes. Justice Albin talked about the LGBT cases. When I started doing those LGBT cases, they were very unpopular. And by the way, I should say something about that. Because one thing that Justice Albin pointed out, and he's right, is that social change comes about in part because the public changes its views of things. But it also comes about because there are courageous lawyers, and there are a lot of them in this room, who are willing to take on those unpopular causes and try to make the world a better place. And I applaud all of you who do a lot of that day in and day out. It's important that we have the courage to do that at times. But it's also important that we know if there's a case, if there's a person or a case, and I'm not saying the president would be that for me, although he would, there would be such anathema to what I believe, it would be wrong for me to take on that case because I have an obligation to represent my clients zealously. And if I can't represent them zealously, I shouldn't take on the case. You can criticize me, as my mother did, if you take on something that you don't believe in. But I think you have to have the sense that you really care, that you're really going to do the right thing before you take on a case, and that you can do that, accomplish that zealous representation. If you can't do that, you shouldn't take the case, and that's my measure. If I don't think I can do it right, I won't do it.
Rabbi, you work for the Simon Wiesenthal Center. Simon Wiesenthal Center has dedicated itself to Simon Wiesenthal hunted down Nazis, to bringing about tolerance, fighting injustice, representing Nazi war criminals. There were articles recently about Ben Ferenc, who's the last surviving prosecutor of the Nuremberg trials. He's 99, he lives in Florida. Morally, do you represent a Nazi war criminal, or do you say, I'm not going to take that kind of case?
Our system of justice demands it. Our legal system holds open to every person the right to a trial and to vigorous defense. And I think in the end it boils down to the something similar to the old adage about people and the wonder stories of great Hasidic rabbis. And we used to say back in Europe that somebody who believes none of the stories of these wondrous rabbis is probably a heretic, and somebody who believes all of them is probably a fool. Everyone out there we should all feel obligated to uphold the legal system, and that means from time to time taking on cases that we don't particularly like and find loathsome. There are people out there who seem to specialize in them, and might as well hang out a shingle specializing in sleazebags. That often points to some kind of a character defect. But I would say, to answer your challenge, yes, even the Nazi criminal is entitled to that defense, and somebody should do it.
Judge Wecker, when you're a judge, you're involved in a case, and someone in the case would be deemed repugnant under normal circumstances. How do you put aside your own personal sentiments and feelings when judging a case that comes before you, where one side or another, or possibly both, are just people or share views or have done things that you just can't wrap your head around?
Two thoughts in particular come to mind. Before you asked your question, listening to the distinguished members of this panel with whom I'm privileged to sit tonight, I'm struck by the fact that when you're a judge, one of the luxuries you have, apart from giving up the opportunity to make partner and drive that Mercedes, is that you don't have to worry about what clients are going to think. You don't have to worry about what business you're going to get or lose. The business comes to you. And that is, in fact, a luxury. The other side of that, as you just pointed out, Rabbi, is that sometimes cases that come to you do involve people. Probably it happens more on the criminal side than on the civil side. Happens in the family court also. People come before you of whom you personally might disapprove. And that gets to an issue that's gotten a fair amount of attention in the law and in psychology that's come to be called inherent bias. And that is that all of us have an obligation in our roles to recognize that we are as subject to inherent bias, things that we might have picked up along the way from the time we were little children, whether it was language that a grandparent used or that we heard around the house. And I think the thing we learn, or hopefully we learn, is not to pretend those biases don't exist, but to recognize them, deal with them, discount them consciously, but on the other hand, not overcompensate. And that is one of the challenges sitting on the bench.
Chris, you wanted to jump in.
I just think there's an interesting distinction between, I'll just use the colloquialism, not having the stomach or not having the desire to represent a child pornographer, let's say. I get that, and that kind of work is not for everybody, and for the people who it's not for, they shouldn't do it. But to not represent the child pornographer because you don't agree with his political views, to me, is off. The rule, professional conduct that you cited, and I guess there's some ethics credits, so we'll talk about it for 15 seconds, doesn't talk about taking on the representation. That's up to us. We decide who we want to represent and not represent, and we make that decision freely every day. That's about withdrawing. And I think it's an important distinction. And thankfully, the rules also say that, the views of your client aren't your views. Rule Professional Conduct 1.2 says you don't necessarily own those views. And so I try in my own practice, where I think I can be helpful, where I think I can provide a good and zealous representation, to undertake that work and try not to think about what that client's or that company's political views or other unrelated views might be.
Stick to the law. Rabbi, the Bible gives us some pretty clear instruction for judges in a baked-in type setting of how to view litigants and defendants. Could you share with us a little? You have people coming before you that may be of disparate incomes and wealth, and one's a good guy, one's a bad guy. What's the biblical perspective to a judge as to how to view litigants who come before you in a case?
The Talmud is pretty clear about this. Remember, in a Jewish court, there are no attorneys. There's some other advantages to Jewish courts. I once met Justice Kennedy at Loyola Law School, who said that he's a great admirer of Jewish law because he heard that when the court comes to a decision, they do not have to file a written record of their reasoning. He would love to be governed by Jewish law. In Jewish law, there are a couple of rules. I'll go over them very, very briefly. One is that the Mishnah, part of the Code of Jewish Law, earlier than the Code of Jewish Law actually, talks about the obligation, the psychological obligation of the judges. It's a panel of judges, not a jury that tries cases. They should look at all the people in front of them as if they are as guilty as sin, and suspect collusion, suspect deception, suspect the worst on both sides, because it's the only way you're going to get to the truth. And after things settle down, after you arrive at the verdict, then everybody should seem to you as an angel. Getting there, both parties have to appear before you as equals. The Talmud says if you have a rich person and a poor person coming into court, and one of them shows up in an Armani suit and the other one's dressed pretty much in rags, you tell the Armani guy, you either send out for an Armani suit for your opponent, or we'll get you some rags. Because how they appear before the judge in court does create an inherent bias, and they have to appear as equals. So much of what we suffer in terms of the popular conception of law is the idea that the rich get a much better shot at the law because they're the ones who can afford better representation, and there's this perception of inequality in the way we do law. And there is some truth to it. In Jewish law, that is pretty much covered.